The Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you, Madam Clerk, and welcome everyone to the call of the April docket here in Jackson, Tennessee. This is the second case of the afternoon, and Madam Clerk, if you'll go ahead and call the case, I'll release you and I'll talk to the attorneys.
State of Tennessee versus Will Vaughn.
Thank you, ma'am. Gentlemen, we conduct these types of oral arguments in the same fashion we do if we were having in-person oral arguments. Each side is awarded 20 minutes. Should you wish to reserve any time for a rebuttal, the appellate may do so upon introducing himself to the court. And with that, we consider ourselves, as Joe Riley used to say, a hot court. Don't know how hot we are, but we're sure lukewarm for sure. We've read your briefs. We have somewhat of an understanding of the issues that are going to be presented today, but there's always a possibility that and a need for you to be able to expand on what you tried to tell us in writing, and that's why we have these particular arguments, to let you fully develop what it is that you wish to tell us. So with that, the appellate may start now.
Good afternoon, Your Honor, and may it please the court. I'm Price Rudolph. I'm from Shelby County, and I represent the appellant Will Vaughn. At this time, I would like to request to reserve 2 minutes for rebuttal.
I'll keep it up with it for you. Go right ahead.
Thank you, Judge. Today, I'll primarily be addressing on two issues. The first issue I'll be addressing on is whether there is sufficient evidence to convict the appellant of the crime of employing a firearm during a dangerous felony when facilitation is not enumerated as a dangerous felony under the statute. And the second issue I'll be addressing is whether the court erred by finding there's an adequate basis for imposing consecutive sentences. I'll start by giving some brief background on the case. I probably won't go super in depth since we're not reviewing all of sufficiency, but the incidents that occurred in this case stemmed from a dispute between Alexis Hammond and Termaria Harris. And the incidents were primarily two incidents. There were two shootings that occurred. One occurred on a street called Navajo in Memphis. It was, in essence, a drive-by shooting on a house. There were 10 occupants in the house. The house was extensively shot up, and no one was hurt. There was no physical injuries, but the house was shot up. And this happened early in the morning. Shortly thereafter, a few hours later, about 6 in the morning, I believe, some of the occupants had moved to a house on Fox Lair, and that house was also shot up in a much similar fashion. There were no physical injuries, no one was hurt, and there were about 5 occupants in that house. When the police investigated, they linked this back to a dispute between Alexis Hammond, who was a victim in this case, and Termaria Harris, who was charged as a co-defendant. There was another co-defendant, Brooke Lurie, who did not testify at trial. And they also charged the appellant, my client, Will Vaughn, in this matter. He was charged with 15 counts of criminal attempt first-degree murder, stemming from the incident with the 10 people in the house and the 5 people in the house, and then also 15 counts of employing a firearm during a dangerous felony and 2 counts of reckless endangerment. He went to trial. The jury found all 15 counts of criminal attempt first-degree murder. They found for the lesser included of facilitation to commit criminal attempt second-degree murder, and found him guilty as charged on the employing a firearm during a dangerous felony, and found him guilty on facilitation of reckless endangerment. The court imposed partial consecutive sentencing. For the first shooting, there were, I think, 3 6-year sentences that ran consecutive. And then there were, on the other shooting, there were 2 6-year sentences that ran consecutive, and they ran the facilitation and the employing consecutive to one another. And I think I put 60 years in my brief. It may have been 54. That might have been a mathematical error, but I was dealing with 32 counts, but I believe it was 54 in there. So just going back to the argument, the appellant maintains that that the evidence is not sufficient to convict him of employing a firearm during a dangerous felony because he was only convicted by the jury of facilitation. The word facilitation doesn't appear in the statute, and the plain language of the statute doesn't reflect that a defendant could be convicted of employing a firearm when he's convicted of facilitation. If you look carefully at the statute 3917-1324, it distinguishes between commission and attempt in the first or under subsection B. And that sort of, at least to me, indicates that the legislature sort of contemplated lesser included and inchoate offenses and distinguished something like an attempt from the underlying actual commission of a felony. And reading the statute, once again, it doesn't have facilitation in it. And I would argue that because they put the particular language of attempt in the statute, but omitted the particular language of facilitation, or you could argue something else like solicitation, the legislature wouldn't have intended on putting that in. And it's the appellant's position that he could not be convicted under the statute as it's written for employing a firearm during a dangerous felony because he was not convicted of a dangerous felony.
Well, the state's argument seems to be, or answer to your argument seems to be, that these are just inconsistent verdicts.
And there is some truth that this is certainly a case of inconsistent verdicts. I'll go back to the record, and when the trial judge instructed the jury, he specifically instructed them, you should not find the defendant guilty of employing a firearm unless you return guilty verdicts for criminal attempt first-degree murder or criminal attempt second-degree murder. He did not include facilitation, even though it had been charged in the jury instruction. And the jury definitely did not, I mean, they pretty much disregarded that, the trial court's proper instruction. And so it kind of is a case of inconsistent verdicts. I'm very aware that in Tennessee, inconsistent verdicts are upheld. But I would argue that this rises to such a level in how it contradicts the plain language that just the evidence is just not sufficient. Though I will definitely agree that this also is sort of a case of inconsistent verdicts. And I would just ask that the court under these facts apply the plain meaning and dismiss the 15 employing a firearm during a dangerous felony charges. And if there are no other questions, I was going to move on to consecutive sentences. In this case, as I said prior, there was partial consecutive sentencing imposed. And the court gave its reasons at the sentencing hearing. They found by preponderance of the evidence that Mr. Vaughn was a dangerous offender, and that's in the record. And the trial court also expressly found at sentencing that the defendant's behavior showed no regard for human life and little hesitation to commit a crime where human life was high. And I believe he also found that the sentence was reasonably related to the offense. However, under State versus Pollard, the trial court needs to make a finding that that the sentence is necessary to protect the public. The trial court made express findings on the prior elements, but never made an express finding on it being necessary to protect the public. And I read the state's brief and understand that they're arguing that they're contextual, that you can read into it some of the reasoning and say that, well, even though the trial court didn't expressly state it, that you can infer that it's necessary to protect the public. But I would argue that because the trial court should put it expressly on the record. The trial court put all the other elements expressly on the record, and I would ask the court to adopt a standard where the trial court, in finding whether the sentence is necessary to protect the public, will expressly state the reasons. And because of that, I would ask the court to review this de novo, because I would argue that the trial court failed to put adequate findings on the record in regard to Mr. Vaughn's sentence being necessary to protect the public. Regardless of whether this is reviewed de novo or under an abuse of discretion standard, I would argue that the aggregate length of the sentences does not reasonably relate to the crime. The first thing I would bring up is the fact that the defendant was only convicted of being a facilitator. And I know that the state has sort of raised in their brief that maybe the jury was cutting him some slack, and that's why they convicted on the employment, but only convicted on facilitation. But I would say that realistically, the jury, they would have contemplated these things and carefully found and convicted him on facilitation and had reasoning behind that. So the first thing I would bring to the court's attention is that he was only convicted as a facilitator in this crime. The second thing I would bring up is that no one was hurt in this crime. No one suffered any permanent or temporary physical injuries. At the end of the day, though, people were frightened, and this certainly was a serious crime. Really only property was damaged at the end of the day. And I would argue that a 54-year sentence for a crime that no one was hurt in really doesn't reasonably relate. That length doesn't reasonably relate to the offense that was committed. And lastly, I would argue, just as a general principle of sentencing, we intend to see fall that the sentence should be justly related to the severity of the offense. And I would just submit to the court that in the present case, a 54-year sentence, once again, for someone who is convicted of facilitation, in a case where no one was wounded, no one was hurt, though there was a high probability of being hurt, but at the end of the day, no one was wounded or hurt, that sentence really does not relate to the seriousness of the offense, but goes much more above and beyond the seriousness of the offense. And for those reasons, I would ask the court to either review the sentencing de novo and reverse the consecutive sentences, or remand the case to the trial court for further findings. And that's nothing further, Judge.
You have your full rebuttal time. General, what say you?
Excuse me. Good afternoon, Your Honors. If you allow me to start by expressing my personal sorrow and about Dorsey and Mia. And I know Your Honor mentioned that at the beginning of the docket today, but I did not know Dorsey so well, but I knew and loved Mia. She was wonderful to work with. So I'm very sad over here about that news.
Thank you, General.
I want to start very quickly addressing the 60 years versus 54 years things to see if I can clarify anything on that issue. During the sentencing hearing, the trial court said 60 years. And if you add up the sentences the trial court said, it equates to 60 years. The judgment sheets only show 54 years. What's interesting about this is that the judgment sheets have written on them, handwriting in the special conditions box saying 54 years, total effective sentence of 54 years. So I went by 54 years in my brief because that's what's in the judgments, both in the special conditions box and if you add up everything that judgments did. But any confusion there is because the court at sentencing said 60 and imposed a sentence that would have been 60. Moving on, addressing the employment of a firearm, and I think Judge Williams said our position pretty clearly. This is an inconsistent verdict issue. He was convicted of employing a firearm during the commission of or attempt to commit a dangerous felony. The dangerous felony was specified by the jury as attempted second-degree murder. It's true that he was convicted of facilitation of attempted second-degree murder in other charges, but for the 15 weapons charges, the jury specified in each and every one that the underlying predicate felony was attempted second-degree murder. By statute, that is defined as a dangerous offense. And so there is there's no violation of the statute there. It's clear. If there's any issue, it's an inconsistent verdict. And as I pointed out in my brief, and as this court is aware, and as Mr. Rudolph has acknowledged, Tennessee law says you don't get into the jury's reasoning on that. My favorite quote on the issue is that you don't know whose ox has been gored. And I cite that in my brief. So I'll just leave that there unless there's further questions on that issue. All right. I'll turn to the sentencing. First, with the dangerous offender, Pollard is clear, and the subsequent case law is clear that you must also make the additional Wilkerson findings. And Mr. Rudolph is correct that the trial court did not explicitly say that the total aggregate sentence is necessary to protect the public. However, the trial court made some findings on the record that essentially amount to that. One of them was its reliance on the risk and needs assessment, the strong R assessment, where Mr. Vaughn was assessed a high risk for violence. The trial court also referred to the severity of the circumstances of the offense. I believe he said that people were, quote, in the line of fire during these offenses. So the court really looked at what happened here, and it's the state's position that made the implicit finding. I think what happened here is the court was relying on the old standard that you have to have the circumstances were aggravated, and the court did say that the circumstances were aggravated, excuse me. The new standard is that you have to say that the sentence is necessary to protect the public from further criminal acts. But again, reading the court's ruling, I think it's an implicit finding in its ruling. I think what's interesting here is Mr. Rudolph is asking this court to adopt a new standard that has never been announced, and that is that if you make the Wilkerson findings, the trial court must also say why it's necessary to protect the public and make that even more explicit. That's what I understood from his oral argument. And if I misunderstood that, I'm wrong, but I heard him say he's asking the court to adopt a standard. And I think it's interesting to ask this court to do that. That's not what the law is. It is the case that this court can find an implicit finding by the trial court, or this court can review de novo. And I would submit on this record, de novo review or the implicit finding. Either way, you'll find he is a dangerous offender. The other thing that Mr. Rudolph relies upon a lot in his argument is that nobody got hurt. But I would suggest that is not because of anything the defendant did or did not do. Mr. Vaughn essentially got lucky that no one got hurt. The testimony was, especially with the first house, that the shots went right above where people were sleeping. And at least two of the victims testified that if they had been sitting up instead of lying down, they would have been hit. Debris fell on one of the infant babies that was in the crib. I mean, this was not, he didn't shoot into some unoccupied part of the house as a warning. And again, I would point out the jury here found expressly attempted murder, at least with respect to weapons charges. Lastly, this argument that he was only a facilitator. Well, it's one thing to say he facilitated, a theft. Here, he was convicted of facilitating an attempted murder. That's a pretty serious deal, and it was 15 times over. This was two separate houses that were shot up. They were chock full of people. In fact, reading the record, they didn't charge for every person in every house. There were some people that, some victims that went uncharged. So with respect to the reasonableness of the sentence, 54 years is really almost lenient for the facts of this case. So unless there are further questions, we would ask this court to affirm. Thank you, Your Honors.
Mr. Pellant, back to you, Mr. Rudolph.
Okay. Thank you. I'll first start by clarifying my statement on the consecutive sentencing. The trial court at sentencing was explicit in their findings on Mr. Vaughn being a dangerous offender, Mr. Vaughn's actions showing little hesitation as far as towards human life. And I would just ask that the trial court also make an explicit determination that this sentence is necessary to protect the public. And I think that's really what I'm asking, if as far as the court to look at adopting is that if you're going to find that it's necessary to protect the public, just expressly put that on the record, because the trial court put all the other factors on the record and expressly stated them, making it very clear and unambiguous. But as to whether it was necessary to protect the public, I would submit it is ambiguous, a 54-year sentence. And just going back, I'll just echo my argument that really the appellant is a facilitator. In 54 years, it does seem just not remotely reasonably related to a sentence where no one was permanently or temporarily hurt. It just seems to really not fit the crime, and I would submit that. And I'll just end on the facilitation argument. I'll admit there certainly is a degree of jury verdict inconsistency in here, but I would submit to the court facilitation doesn't appear in the statute. The jury found him guilty of facilitation, disregarded the trial court's instruction, and then just found him guilty of attempted, or just put attempted second-degree murder without actually finding him guilty on the verdict sheets for employing a firearm. And I would just submit that under the plain language of the statute, that is not sufficient to convict the appellant on the 15 counts of employing a firearm. And that's all I have, Judge.
Mr. Rudolph, I have a question. Did you find any cases where the verdicts were so inconsistent that the courts held they were irreconcilable?
I did not. The main case I looked at was the Johnson case, because it had sort of similar. It was similar to this case. It involved an attempted first-degree murder or a facilitation of attempted first-degree murder, and the jury found for employing a firearm under theory of first-degree murder. I think the court only addressed in that case on the inconsistent verdicts, and they upheld it. But I did not find any case where they were so irreconcilable that that the court overturned them.
Thank you.
Mr. Rudolph.
Yes,
Mr. Rudolph, were you appointed on this case?
I was, Judge.
All right. I just wanted to say two things. Number one, we appreciate your accepting the appointment and helping our court move this case forward. And number two, you wrote an excellent brief and made an excellent oral argument today. And I hope you'll continue to accept the appointments on these cases, and look forward to seeing you again.
Certainly, Judge. Thank you.
I too would like to compliment you. Understand this may be the first oral argument that you have participated in front of the Tennessee Court of Criminal Appeals.
Yes.
Well, welcome. I hope you find your experience here painless. Sometimes some don't. You had very good time management of your argument. You knew your case. You knew the law. You knew what you wanted to ask us to do, and you had plenty of time to do it. Very well done. And as you can bet, when you go up against the state of Tennessee, you're going up against seasoned veterans. And Mr. Waddle is up for the task. General Waddle does a good job as well. So we always compliment him, but we really like to know when it's your first time. And we'd love to see you back.
All right,
Judge Holloway?
thank you, Judge. This was my first time.
Judge Holloway, anything from you?
Nope, good job, both attorneys.
I also want to take the time to thank you for appearing in this format. It's more difficult to Zoom than it is to be in person, or at least wise it is for me. And I appreciate whatever effort you had to date, whatever accommodations you have to give the court to do it this way. I think it looks quite professional. I think it is a very good substitute, but it's still a substitute. We hope to get back in the courtroom very, very soon, hopefully as soon as June. And with that, we couldn't do any of this without the assistance of the staff of the clerk's office and the assistance of the AOC. They are doing a phenomenal job, and we always wish to thank them. Thank you both for the arguments today. Please adjourn court to 3 o'clock.
This court is now recessed until 3 p.m.
Thank you.
Thank you.